that did show up and have proof that she's done 50 community service hours. That does that, she's just taken that to probation because they're gonna have to actually verify the hours. If they do that, they'll email us, and at that point, I'll have the, we'll know across the case is successful completion of the conversion, but we do have to have probation to verify it.
So for purposes of today, Judge, we can set this for a status on April 28th.
And it should be off the document for you for that.
The state agrees.
Yes.
So the loan violation cited was the 50 hours community service. Otherwise, the whole period of monitoring had been accomplished.
Yes.
All right. So let me have my assistant then put that on the calendar. It will be canceled.
4/28 at 9 o'clock.
Right. You can coordinate with her on that. All right, very well. So to be removed if it's confirmed, if not for the hearing.
Yes, sir.
All right, very well.
Thank you. Thank you, Mr. Rogan.
Have a good day.
The case that is the longer case today is State v. Francois, 19 CF 2266. Mr. Verderamo for the defense.
Good afternoon, Judge.
And hello, Mr. Francois. How you doing?
How you doing?
Okay, thank you. Please be seated. Ms. Wilson, greetings. And do we have a witness here?
Yes, you're
All right, greetings, detective or officer, I'm not sure. All right, so this is a defense motion to suppress. Any preliminary comments?
Judge, before we begin the housekeeping matter, I would have first appearance for two gentlemen at 2 o'clock. I'm going to ask to take about a 5-minute recess at 2 so I can make those appearance. I've let the state know Mr. Stewart is going to address my cases and I'll be able to come right back. I let them know that I'm going to have an issue.
Any objection?
No.
All right. Additional preliminary comments. I have reviewed the motion that was filed. One thing I was going to mention, obviously, Mr. Verderamo, I don't know if it's going to be an issue in this case. It will depend on the evidence and the law that is referenced by the parties, but there was part of your motion dealt with the odor of marijuana in this case, and you cited to some of the case law that this court cited.
Mr. Ward actually wrote the motion because he was counsel at the time.
Okay, that's right, yes.
I did subsequently file a motion to adopt, and I will address, ironically, Mr. Ward wrote the motion, and I think the case law is the word out of the second district. Okay. The new opinion that just rendered.
Right, that's what I was getting to, which is that this whole issue of the odor of marijuana, the second district court of appeal, I believe it's the Owens decision very recently,
Yes.
Cited with disapproval, not approval, this court's decision in the Nord case.
I'm aware of it, Judge.
All right.
I'm prepared to distinguish that case.
And the state was aware of that authority also?
Yes.
All right,
We both have the opinion, the recent opinion.
okay,
And I believe it is distinguishable from this case.
all right. Ms. Wilson, any preliminary comments?
Nothing from the state.
Are we ready to call the witness?
We are.
All right, if you want to come up, sir.
Your Honor, state call staff officer John Studer.
So that he faces court right hand.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
I do.
Welcome, officer.
Good afternoon.
Please be seated, thank you.
Good afternoon.
Good afternoon.
Would you please identify yourself for the record and spell your last name?
Yes, my name is John Scaduto, S-C-A-D-U-T-O.
And where are you employed?
Currently at the Lee County Sheriff's Office,
And how long have you been employed there?
approximately 2 months.
And what are your duties there?
I am a staff officer assigned to the Community Response Unit.
Okay, that's a different name, different magnitude. Is there something more specific?
Under that unit, we do have a section of community policing, selective enforcement team, and community outreach centers throughout the county.
And where were you employed before that?
The Collier County Sheriff's Office,
And how long were you employed with the Clark County Sheriff's Office?
approximately 13 years.
And what was your rank with the Clark County Sheriff's Office?
When I left, I was a senior detective corporal with the Collier County Street Gang Unit.
Okay. And before you came to the Clark County Sheriff's Office, did you work as a law enforcement officer?
Yes, ma'am.
And where was that?
Commonwealth of Massachusetts.
Okay. And what was your rank there?
I retired as a captain with the Suffolk County Sheriff's Office in Boston.
And how long were you with them?
With Suffolk County, almost 15 and a half years.
And during your time as law enforcement officer, have you received training in the area of identification of marijuana?
Yes, ma'am.
And what type of training did you receive?
Going back from inception, the basic training conducted by the Massachusetts Department of Corrections, training conducted by the Massachusetts Criminal Justice Training Council, specialized classes with the Massachusetts State Police, with the United States Drug Enforcement Administration, and periodic updates through the Massachusetts Sheriff's Education and Training Committee, as well as Barnstable County Sheriff's Office, Essex County Sheriff's Office, District Attorney's Office in Massachusetts. Florida, I did receive orientation during the crossover and academy for the state of Florida as well.
Okay, and that training includes both the identification to smell and to its texture and what it looks like?
Yes, ma'am.
And during your time as a law enforcement officer, have you had, during part of your duties, have you had come in contact with marijuana?
Yes, ma'am.
And did you become, again, familiar with its texture, what it looks like, and what its odor is?
Yes, ma'am.
And how many times did you say you come in contact with it?
To give an exact number, I can't, so hundreds, it would be in the hundreds between the years of the service.
Right. Taking your attention back to December 11, 2019, what were your duties with Clay County Sheriff's Office at that time?
I was senior detective corporal with the street gang unit.
And on that evening at approximately 1900 hours, where were you at?
I was on a directed patrol at the Whistler's Cove apartment complex in Collier County.
Is there a specific reason that you were patrolling that area?
The gang unit had been occupying the complex for almost a year due to increased gang activity, which includes narcotic sales, narcotics use, shooting incidents, which are all substantiated in office incident reports, and at least 2 shootings that I'm personally aware of, including a shooting in broad daylight, where 18 shell casings were found.
Okay. And is there a particular area of the complex where a lot of this gang activity was taking place?
Majority of the gang activity was focused to the rear of Whistler's Cove, and the reason is there is a walkway that connects Whistler's Cove and residents to Eagle Lakes Community Park. That same pathway goes out through to the Naples Manor through Parkside Elementary School. The particular gang that we were working, and my understanding still working, is primarily based and was based out of Naples Manor, which is the neighborhood where that pathway leads to.
Okay. And were you working with the community and the homeowner association in regards to this patrolling?
Yes, we were working with the property manager in an attempt to quell the activities in the community, which actually had forced the property manager to move and actually move to a different county.
Okay. And did they ask you to make contact with individuals in regards to whether or not they should be trespassed or not?
I'm not objecting to hearsay.
You know, if there's a motion, Dr. You can talk to your, you can address hearsay during that.
I'll object to relevance.
Overruled.
Okay. Go ahead, Nick.
Yes, the property manager had made it clear that if we did encounter non-residents in the community, unless they were accompanied by a guest, that they would be trespassed, because we had shown that several of the non-residents were coming to the complex to engage in nefarious activity there.
Okay. Now, going back to that evening, again, about 1900 hours, did something come to your attention?
Yes, ma'am.
And what was that?
While I was patrolling and heading to the rear of the complex, I noticed a light-colored white car, and I distinctly remember it had Tennessee tags on it, so it was probably a rental. There was a male outside the vehicle. From recollection, I believe at least one female in the vehicle, and there was another subject that, upon the headlights coming in, actually moved to an area within probably, and again, guesstimate, 8 to 10 feet away, a couple of trees, a couple of telephone poles. From my experience, in an attempt to try to hide themselves and blend in with the background.
Okay. And then what happened?
The vehicle subsequently pulled out, and the male that was behind the tree pole area left the Whistler's Cove property and started walking down the pathway that I described, heading towards Parkside Elementary School and to Naples Manor.
Okay. And then what did you do?
Made a judgment call, try to follow the vehicle, get some pertinent information, or follow the individual down the pathway and see who, if I can make a contact to see who it was.
What did you do?
I followed the subject walking down the path.
Okay. And then what happened?
Prior to coming to the subject, I actually activated my in-car camera to record the interaction. I had a pretty good assumption that it was Mr. Francois due to the unique color of his hair at the time. It was dyed kind of reddish orange, but wasn't 100% positive.
And then what happened?
I drove next to him, seen it was Mr. Francois. He was on the phone. I asked him if, in fact, if he was in Whistler's Cove. He denied it. I challenged him on it. And during that interaction, I did detect the aroma of marijuana.
Okay. And then what happened?
He was talking on the phone to someone. I think he said something, he felt threatened or police were harassing him. I just asked him again, you were on Whistler's Cove or not? He didn't answer, and then I proceeded to the end of that walkway, which is the entranceway to Parkside Elementary, for a couple of reasons, if I could articulate.
Okay, let me back that
Sure.
question and we'll go to that. Now, so you waited, after you smelled the odor of marijuana, you decided to wait, to detain him? Is there a reason why?
Yes, it's on a narrow path, so there is a way to continue forward. There's also a way to retreat for the individual. Tactically, it wasn't a good area to make that stop, dim lighted, etc. I'd rather wait till the wide open area, better lighted situation. Mr. Francois has been known to carry firearms, and the utmost officer safety point of view, and get me time to collect my thoughts, I went to the end of the walkway and waited for him to approach me.
Okay, and then when you parked, did you block him in at that point?
No, ma'am.
And then once you came in, you parked at the end, what did the defendant do at that point?
He walked up to me, I got out of the car, encountered him again, and then asked him about medical marijuana card, asked him for his identification. During the exchange for medical marijuana card, he did indicate that he had one, however, he did not have it on him.
And could you still smell the odor of marijuana at that point?
In fact, it became more pronounced once I got out of the car and was closer to him.
Okay. And did you verify whether or not he had a medical marijuana card?
Yes, I did. I radioed his driver's license / ID number to dispatch, confirmed that it was in fact Mr. Francois, and then I asked, in Collier County procedure is that the communication supervisor would be the one that would ascertain if an individual had a medical marijuana card. That process was initiated and subsequently returned that he did not have a medical marijuana card.
Okay. And did at some point you call for backup?
Almost immediately, once I knew who it was, at the entrance to Parkside and the pathway.
Okay. And then what happened next?
Once I received backup, another marked uniformed officer, again, questioned Mr. Francois. At some point, he was told he was detained, and then we did locate contraband, synthetic THC products on him, marijuana, and eventually a small pill was also located. All of the items that were found on him, including one item hanging around his neck, that's where the contraband was detected.
Okay. And so you did find marijuana on him, correct?
Yes, ma'am.
And how much marijuana did you find on him?
If I-
Sounds like it's still emotional.
How is that relevant?
Where it just goes to the fact that they smelled over the marijuana, that, how much there was, what was exactly.
I find it as relevant as to any observations as to order overruled. Go ahead, you may answer.
If I could refer to my report for the exact one.
You need that for refreshment?
Yes, please. Counsel.
Yes.
Thank you. There were 2 glassine plastic bags that were located in his property. One contained unpackaged green leafy marijuana. And I believe that one, well, both were over 20 grams total package weight. The loose suspect marijuana was 28.4 grams. An additional plastic bag was also located separate from the loose marijuana. Those were individual packaged containers of marijuana, and that weighed in at 38 grams total package weight.
And did you also locate a killer in regards
Yes.
to? Okay. And did you ask the defendant in regards to whether or not he had hemp on him?
Yes, and it was towards the end of the interaction, but I did also ascertain if he had any hemp products on him. And to my recollection, also, I believe in the in-car video, he did not respond.
And are you familiar with the statute in regards to smokable marijuana?
Medical, correct, yes,
Marijuana, I'm sorry.
yes, ma'am.
And do you recall how much it is that you have on you?
If I could refer to my notes to be exact,
Just for the memory?
yes, ma'am. I believe it's
The gentleman objects to this line of questioning. It's outside the scope of the motion. He's not even prosecuted for possession of marijuana.
Your Honor, however, it still comes down to the probable cause to be able, in regards to search, and, we're going to look at the fact of whether they make any argument that it couldn't, that he didn't answer in regards to him, that it could not have been medical marijuana that he had on.
What's the question again, Ms. Wilson?
But I was asking how much you can have of medical marijuana on you at a time.
Objection sustained.
Okay, so you can't. And if I may ask you, was it packaged as medical marijuana?
no, ma'am.
Object all this. You already asked her how the package was, how the marijuana was.
Objection sustained.
Your Honor, may I approach the witness?
Yes. Has opposing counsel reviewed?
The video? I'm fine. No objection. You don't have to lay the break with people.
So you're stipulating to its
I'll stipulate,
admission?
yes.
This is state what exhibit number, Ms. Wilson?
Your Honor, you state exhibit 1, we asked to publish it, although at this time,
The video, I believe, is going to be about 13 minutes, give or take, from when Mr. Francois was placed in custody. We're right at the mark. If I could-
Oh, all right. You want to take the recess
If I could,
now?
we could take a recess and then reconvene with the video.
Okay. Does the witness need to be elsewhere, or are you able to remain?
No, sir.
Okay. All right. We'll take the recess and wait for Mr. Verderame to
Thank you. I
return.
apologize, everyone.
And Mr. Francois, if you need a break, you can step out just to make sure you come back with your counsel. All right. Let me know, Officer Harrison, when everybody's ready.
Yes, Your Honor.
Thank you.
All rise, court is in recess.
Yeah.
You never called me for a job, I literally. You want me to call him right now?
Yeah, you're going to jingle, so I bet you don't answer your phone.
Yeah.
I'll bet you a cold lunch sandwich tomorrow, that's your phone. Unless they don't want
You can go somewhere there. No, I just. Come right to the email. See yourself? Yeah, go ahead, go jingle. Go ahead, well, great. See, you got hair on your ass. Shit. No wax. Yeah, bleach. No wax, bleach. French finger. Yeah, here, there anyway. You look over too. You do anything you got her. You want nothing about us? Yeah, no, you're the snakes. It's just up there. No. No, you don't. Oh, the change up there, there's a lot. Yeah. But I know the key snakes. Also, when you're free. No, yeah, I did. You got nothing to do over the weekend. No. I am so busy, I can't even make sure. What do you got to do that? You don't even do that. Yeah. No, I'm not good. Are you not? You don't even leave the house, so what are you busy doing? You're not really at your house. What are you doing? I'm doing all kinds of things. I'm not home. Okay.
What made you move up north?
Time to go.
Time to go?
I'm
I feel that way every day.
old school cop and, Thanksgiving, and it wasn't necessary. I want to talk with, Jim, probably about 9, 10 months ago. After dealing with those things, I can't remember. We're done. Yeah, 40 years, stuff like that. I'm gonna catch a piece of paper.
I still haven't shot my hair. My thing was that.
What brand was that? And I'm all set to start teaching the academy, training for. You can't,
I would even shot that.
so. We're done. Maybe an awesome.
Yeah, yeah.
Me too.
That's the one you bought. That's the one you bought. That's the one you bought.
Another thing too, there's a bunch of us. My work, I was all over the country. Same thing. When I first got on, I was part-time. Lieutenant, captain, he says, hey, kid, can you fight? Yes, so. Because everyone wanted well, they call my son, I get PC. You have to fight. Things have changed, you know, he never. Just go there. I mean, they listen to you. And that's another and basically, it was a combination of things. She sat right at my all of a sudden, there were cameras on the games. My first because we got like that shooter is where he's in the West Coast now. Bad actors. He's on the record. So this. He just signed Hi. You should keep on coming in, right? More school. But it's just, like I said, it wasn't necessary. Things change. I get it. That's what we try to do. I'm not allowed to take
Yeah, for you, we don't.
It might be better. The U.S. at least reform bill passed. That's all. Some of that mass language is boilerplate. So there's one thing, it's chill, said. It basically said, I was situation. What did the officer ask you, at least for the word terminology, the slow my situation down. But slowing down means different for you to, I don't mind taking suspension. I was in California, and he went back to LAD. A state of dispatchable home. You come down, you're not on dispatch. That's not replicated. We're only 7 months old. He's right. It's on the 18th. Yeah. First surgeon. These 2 months, 5 years. I'm going to be able they don't have any candidates on this.
Although it's a close, it's a thin line.
You're gonna get my voice out of it. This is my opinion. Very happy. They made me very well. Stayed over. 2 of us in the state of the cycle games. But sorry, I'm not going to allow that. I don't know if it's changing. I don't get mad at this. Won't be a very friendly. This one.
That's what it says, 45 minutes. You said 5 minutes.
Sheriff Montesino was expecting me back today.
I'm sorry.
Sure he is.
He is?
Carmine's already gone home.
No, he's not, we got an event tonight.
I thought you said that when I walked in, I said that if I never stopped, because they come back and I went, you're early. Because I was like, he's in a suit.
Yeah.
I said, he's really cool, yeah.
Carmine's already gone.
I get there every night, but
No, and actually, the guys at the jail, my kid works at the jail, get ready to go up the street. He said, come on, at the jail, about 2:31. He's supposed to.
Mm-hmm.
He's supposed to, that's his place, and you just can't do it once a year. You have, I'm a firm believer in management by walking around. You have to be, you gotta see it.
We need to get our man out of the office on the road so it's useful.
Yeah, ours, you know how ours is. Be nice to understand.
It's God's lovely world.
Yeah. Ours is, that's their heads, I can say.
Testing 1, 2, 3.
They're scared to get out of their room.
Yeah, plan on it.
All right, it's 2:15.
Okay, there's a real shit. in this area. Well, just north of this area, on the west side of 41. You know where Breckenridge Bath and Tennis Club is? Breckenridge Bath and Tennis Club? The Cerro?
Yeah, no, I know it's sour, sorry.
Okay, you know where they're building a new Suncoast credit union?
Oh, no, okay.
All the way in the back, there's a Lari, well, Bel Air Estates. Real bad neighborhood. There's a guy that built this 6-car garage, and he's got all these collector cars. He is dealing drugs like you would not believe.
Oh, your brother was
She don't even remember.
We're on a quarter paperback.
There's this old lady, she's about 90 years old, her name's Teresa Lagoon. We're actually this and that now. Teresa this and that. And
It's still a little bit of a wow, I'm actually gotten more comfortable, I can be a little bit more comfortable.
she looks like the old lady from Wedding Singer that got paid by the meatballs. You know, she looks like her, but she lives at this one house. There's a 6-car garage. When the house is connected to it, they've always got a trailer. They've got a huge camper out there, a bunch of Mercedes and Jeeps and big, you know, they've got all kinds of stuff going in there.
That's their pizza or something.
It is.
There's an awful lot of street. And St. Paul's Park here.
Yeah. Well, I live down. Actually, I live right next door now. That's my brother-in-law's sister. My mother-in-law lives with me.
I'm a manager, I'm very, we make everybody happy.
Ramiro cleaned it up up there?
Actually,
hell of a handbag.
Huh?
Ramiro cleaned it up up there, or let it go to hell of a handbag?
Well, they let a couple of the units, run roughshod. So they made it kind of rest, but their jail is still, we just had it 2 weeks ago. They have cop bail, I'm hijacking. So we wound up transporting the female in the morning. The female took off, got better. So we bring it to the jail, and the jail's going, ooh, this arrest was only $160,000. I'm like, I'm looking at the kid, and I'm like, I'm new, so I'm just trying to be myself. I'm trying to grab his eyes, like, hey, kids, what are you gonna do? I don't think so. So those are the pitfalls,
He's doing 24 every day. Sounds like there's other activity going on there.
and again, the biggest part of the game, I can split over every minute. You leave your car on, yes, once you got to the mess. Oh, really? Too bad.
Oh, I left my wallet, my son, my car, my glove box.
Why didn't you like my car? People tell me all the time.
What's wrong with you?
The only time we went to your house, if you said you left your gun in the car, we did hunt you out. You go to jail. Well, that's like we were talking about. I'll only go so far, and I'm not gonna care. Everyone's suffering.
This is fixed up. Recently, restocking full liquor store, that broke out this week, they just completely destroyed it and looted it again.
And I don't think I anymore, I just laughed. I tell you something, go get it. Go get it. There's free SBA loan, go forget it.
It's the bigger. Careful where you're going, where you're going. Kidding me? I like put this thing on.
Now, in the big cities, my son is in construction in Mass. And thankfully, he's in residential. So they're still building this everywhere short of residential housing. But commercial, even like New York, a friend of mine, his dad was broke up for years, so they would do all the commission on these big roads. Long story short, is those people aren't. They're not.
Still in front of the working from home, all the other stuff.
Well, what's bad is I had, well, if I don't have to take this long, I would have gotten
Great time.
the now if I go,
It is now.
he come back.
You still have to touch it, right?
Yeah, Max said it'd be about 3 minutes. The city's all the way across the city, across the back of the city now, but things have had to change drastically before I understand it was a trickle there.
This is crazy. You can tell me he handle that and cover that?
He said he had two different things first.
Yeah, but still, he got somebody that work with him.
See my son.
I mean, damn, it's
They're
like,
still programmed.
I don't understand.
Well, yeah, I was just gonna kill it, go over the house. Yeah, they got it really. They can't, so crazy. They're just going to put it like lying down up there.
If they stay here longer, they put their healthcare risk, but they have to pay. Community.
I'm starting on this.
You know what?
At this stage.
It's his motion.
I mean, if these police come in, I mean, I would take them. I mean,
We got to get customers back.
Yeah.
That's right, for my plate.
oh, who is this attorney?
It's at 3 o'clock,
yeah.
Sizemore and,
I suppose not mine, but what it is, well, you know what? Mine got added on
Meza Martinez,
Yeah, that's mine.
and that's an interpreter.
Oh, my God, really?
Yeah, yes,
And Steve Maresca has one too.
he is an interpreter.
We ain't gonna never get out
All
of here.
right, Sizemore,
Sizemore is, that is Steve Maresca's. Probably that's just watching this one because he's in English. Boy, Max is working today, isn't he?
Huh?
Max having to work 24/7.
Yeah.
Busy today.
he's working. You know what? This thing should be kicked down the garbage.
Oh, we were just getting ready to deny your motion.
All right. Let's throw us.
Yeah, they weren't even waiting for the judge. They were just-
Yeah, we should go back.
All right.
Like, what happened?
They have them out of order. They can't call you on this.
Oh, because of the way
The
the
way the
inmates
roster
are.
is, and then once they got to the room, then they called me out of order. So I had to wait till the middle room.
Yeah, I forgot about that.
Oh, because they had multiple rooms.
Yeah, 3 rooms, so I was.
Just like yesterday with us.
Yeah, I had to wait until the whole room cleared out. Sorry.
Yeah, I forgot about that.
I literally took 30 seconds when I got called.
Yeah.
We've been gone almost an hour here.
I have.
No. Wait.
Yeah.
Yeah, well,
What
yeah.
is it?
Oh, I left it too.
Just, no, just put it up in the. Yeah. Or 5 minutes.
I wanted you to feel bad.
So she, yeah, she made-
Hey.
Well, we can finish with him and then redo it. We can.
well, my only worry is.
Oh, I don't think here.
No, that's okay. Hopefully it will be that much longer after that.
I don't think so.
So, because
I
I just need to have some time to get my plea paperwork for the next case, but it looks so free, so I can.
is that why you got an assistant?
You can find it on my desk, which has even my food that didn't get touched. Still up there. I sure hope it's still there after an hour.
That's all right.
I should put it in my refrigerator and see it tomorrow.
Sunday brunch at Capitol Grill for all of us, right? Courtesy of Mr. Bellarone.
And he's so, no,
Macaroni. Yeah.
just the appetizers, you know, it's Florida, right? And you know, you gotta hope that I don't touch it.
Yeah, let's test it, make sure it's good.
Oh, that, it's,
Oh, no.
it's a picture. Okay, do I have to-
Business meeting.
Exactly.
Okay, that works. Now, let's see if I can. Maybe I put on pause without being comments. Oh, is this thing on? Anybody know how to turn the TV on?
There's anything on the side over there? There should be a remote there.
Oh, well, there isn't a vote. Ah, maybe it's working out. Okay, so our TV's on. That's good.
Affidavit needs to be filed separately, so I think I'm gonna send it to Candy.
What's that?
I think my affidavit needs to be filed separately, so I'm gonna send it to Candy. Yeah, don't like those attorneys from state counties.
All rise, Collier County Circuit Court is back in session.
Ready to resume.
Judge, my apologies.
The witness can return, please. State exhibit number 1 has been admitted without objection. And approximate duration, he says about 13 minutes.
I believe so, yes. I imagine the entire video is about 30 minutes, but I believe the relevant portion will be 13, so Mr. Francois will rest it.
I don't know what this thing is that's coming up.
Judge, my apologies to the court. I wasn't aware that I would be in court this afternoon. My clients were arrested last night, otherwise I would have made additional.
Well, we weren't particularly pressed for time this afternoon.
Okay.
If we had been, I might have had to do all
I
other
apologize. The unfortunate thing in my profession is I can never predict my days. I wake up in the morning, it's always different.
Derek, you know what's going on now?
I have no idea. I can, do you have, what is that, Mac? Or not Mac? Do you have HDMI?
Came right up on my computer, didn't it?
Yep.
That's right.
Sorry, Your Honor. We decided to get it going before you got here.
You don't have what you have on it. Do you have, VLC?
I think I'll do a little homework in the meantime, then, for
Yeah, no, stop that.
Try this one right here. Yep, try VLC.
All right, all right. What is up?
I have my computer, but I think it's. Okay, there it is.
We have to.
Your name stop.
You're on, let me know if you turn up.
Is there audio?
There will be.
Okay. A little louder, please.
Would you like us to move it closer?
I think we're okay there. Mr. Francois, you can see it? No, can't? How about like that?
Good evening. Now, come on, you little whistle stove? You were?
What's up? I see it, following
This is not lining up. The sound is all.
Yes, it is.
There's some type of delay.
Is the sound on?
The sound is ahead of the visual.
The sound was an awful lot ahead of the
Subject matter, point of whistle stove.
You know why this is playing?
Ah,
I just asked if you were a whistle stove, why are you doing that? I see the whistle stove right there. I am actually the person at the entrance of the Pineside Walkway.
Can we start over with?
yeah, I'm gonna.
And I was saying, there was no whistle stove. I mean, I have to be a little bit.
All right.
Now, let me just clarify before we start. Is the audio gonna be ahead of the visual?
No, it'll play fine.
I think.
There were two videos playing on two different platforms, so one
Okay.
played about 20 seconds faster than the other one, so that's why the sound is not lining up.
That makes complete sense.
All right, so let's see. Once Mr. Verderamo moves, you can see
Yes,
Mr.
I'm sorry.
Francois? Okay.
Taken. One video, we're still trying to play.
You can just play on that by.
I think the sound kicks in about 10 or so seconds into the video.
Correct, so you can play right here.
Okay, if you hear anything start again, like that other one, try to start again. This one, then we should go here.
Subject must be at point of the person's home on scene of Good evening. Nothing much. You live in Whistle Scope? No, Whistle Scope. You were? No. What's up? I see a officer following me or something. Yeah, man, I know. I'm walking. I just asked if you were Whistle Scope, what are you doing there? I see you Whistle Scope right there. I am actually about to stop out with a person at the entrance of the Pikeside Walkway. Because he was a Whistle Scope. And now he's saying that it wasn't a Whistle Scope. I mean, actually, be a little bit. So I want to call it out here. Right. Go to the location there. 299 Radio 4. Hi. Tell me anything on it, sir? Yeah, but. That's right. No, that's what I am, man. Yeah, we're going to occur here. They're trying to get further information. I can, they're going to call someone. Why are you starting to say? We're going to be, at 1 second. Somebody's going to help you. Make a call from 13 company team. No, get the walkway and watch. I don't think you let's go. Copy 29 minutes, 29 minutes. Sure. That's right. That was exactly. Hey, what's up? Check the game out. 32. soon as I can get a break, I'll run your number, but you were in Whistler's Cove. You went after the vehicle with the Tennessee plates. That female, yeah. I know what I'm talking about, sorry, on camera. Hey, I'm speaking about
Tennessee. So I'm gonna look at Cole, you see me right here. What?
Do you have a medical marijuana card?
Yeah, I got medical marijuana.
Okay, nice. Detect the aroma of marijuana, you sir. Bad deal.
Let me see what's on.
It's not on you?
Check the computer.
I don't know, what percent or anything on you?
I don't know, what is it?
Okay, you mind if I check?
Yes, I do mind. You can just search me up there, okay?
Why ask?
Do mind.
Keep your hands over the ceiling. For the call How long have you had no car? How long have you?
Find out, man. Gotta find out.
Oh, I'm gonna find out.
Yeah, you're there. So what's the end of something?
So Whistler's Cove.
Not in Whistler's Cove.
When I asked you if you're in Whistler's Cove,
I was not in Whistler's
you
Cove.
lied.
I was not in Whistler's
You
Cove.
are in Whistler's Cove, right? What?
I came from the park. I was not in Whistler's Cove.
You were stopped behind that vehicle.
What vehicle?
In Whistler's Cove.
What vehicle?
You're gonna play silly with me anyways, so trust me, if I see you, it's on camera.
Whatever, man. Whatever, bro. What vehicle? What vehicle did you do?
I told you.
It's illegal, man.
No, it's not illegal.
If you're on 62, and I'm not saying I know exactly where an officer is, and you know, I have people that picked up videos of they certainly not on the ground.
What? Not a path. Then I need to hang a wheel over some shit. Hold on, let me check what weapons that we do know that he's had. That's Peter. No, so we'll check it out.
They're here, cheap with everything.
I don't know, I'm not pulling this up.
He tried to say, oh, I'm gonna hold something.
Yes, sir, I'm aware.
Yeah,
investigating and saying he should be criminalized at 10416 Majestic. That's what he tells us. Where is
How are you? Yeah, we got a couple of cars, unfortunately, I don't remember the name right now, but I am working. Okay, thank you. Yep.
Apparently we have somebody that is putting themselves on CDN for a unit response. And Wilton having LIABLE.
Right, sir. That's all. Cops will come off, it's easy as once I find, you claim you have a medical marijuana card, you do not. That was just checked. So you obviously lied. On tape.
So we stopped at about what, number there?
13 minutes.
What's that?
Just over 13 minutes.
So that's about 13 minutes on the clock? Okay.
That's fine.
All right.
13 and a half to 14 minutes in that range.
Okay, so does the state and defense agree that's the relevant portion for this motion?
Yes, and if we're not listening more, I can't.
Yeah.
Ask to leave up just in case we use it on cross-examination.
So, Mr. Verderamo, Will the court need to view anything beyond the 14 minutes?
No, the motion deals up to the actual seizure of Mr. Francois, so everything else at that point is not
Does
relevant.
the state agree it's up to 14 minutes?
Yeah, that'd be fine, Robert. After that, it's just, you'll see the search on it, as opposed to like the recent close.
Okay,
Correct.
please continue.
Excuse me for a second. Mr. Francois, can you pull your mask up, please? Thank you.
Thank you.
Okay, there was a lot of radio noise that was on that we're hearing other calls. That was not in regards to this call, that's correct?
No, at this, in Frank, it's in the same time there was a shooting which resulted in a homicide during this particular encounter.
So that's Sergeant Mills, okay. And at times you could hear Mr. Francois talking, but it didn't appear he was talking to you. Who was he talking to?
I let him remain on the phone. This way his hands are occupied. At that point, we did not search him, and he claimed he was in fear of his life. So even though it was videotaped, I let him continue on the phone.
Okay, and did you conduct the search as a result of the odor of marijuana and finding out it was not a medical marijuana card?
Yes.
And so what did you do? Ask him whether or not he had hemp? I believe you justified with that, correct?
Yes. It was later on in the encounter, but yes, I also asked him regarding any hemp products, which I recall he did not offer a response.
Okay, and not really good. Did you see Mr. Francois in his report where he came in contact with smell the odor of marijuana on that TV?
Can you repeat the beginning part?
You see Mr. Francois, the person that you actually smelled the odor of marijuana on that you arrested that night?
Yes.
Right, and, I have no further questions.
Cross-examination, Mr. Verdramo. Do you prefer the table or the podium?
Where would you like?
Wherever you prefer.
Under the podium. Good afternoon, sir.
Good afternoon.
You testified to your training experience with marijuana, correct?
Yes, sir.
What training experience do you have with hemp?
Not much at all.
Okay. Your agency didn't provide you with any training on the distinguishing between hemp and marijuana?
Not that I recall, sir.
You're aware that hemp and marijuana are indistinguishable by observation, is that correct?
I can't agree or disagree, sir.
Okay. How about the odor of hemp versus the odor of marijuana? Can you distinguish between the two?
My understanding, they are very similar.
Okay. Now, you just testified that you asked Mr. Francois if the odor was hemp. Is that correct?
At the end of the, pretty much near the end of the encounter, yes.
Meaning what we just heard is not on video, correct?
No, not yet. It does appear later on in the video.
Okay, so after Mr. Francois was handcuffed.
Correct.
Okay,
It's
but prior to Mr. Francois being handcuffed, you did not inquire about hemp, is that correct?
Correct.
And another colleague, Deputy Sheriff Lantini showed up as well, correct?
Yes, sir.
And I believe Deputy Sheriff Lantini showed up about 7 to 8 minutes into your interaction with Mr. Francois on the video, correct?
I believe so.
And Deputy Sheriff Lantini walks up, and you advised Deputy Sheriff Lantini what you observed, correct? And you made some statements to Deputy Sheriff Lantini, correct?
Yes, sir.
And Deputy Lantini asked, "Is there hemp?" Correct? Do you remember hearing Mr.?
I do not recall that.
Okay. Would you like me to play the video?
Sure.
Okay.
Judge Mayer, publish it, thank you.
No, so we'll check it out. If we look at it, well, we check with weapons and we do know that he's that. No, so we'll check it out.
Counsel, I did hear that. Anyhow.
Okay. So Deputy Sheriff Lantini arrives and asks any hemp. Asked you, correct?
Yes, sir.
And you responded with, "I don't know." Correct?
Yes, sir.
And you were more concerned about the marijuana card, not addressing the hemp issue, correct?
Take things in there, things that are presented to me, and the first thing was to determine whether the medical marijuana card was present.
Okay, but the other problem of it is hemp, correct? That whole issue was left unattended by you, is that correct?
Initially, yes,
Okay, well, you previously testified that you addressed the hemp issue, correct?
I did.
But it was after Mr. Francois was arrested, correct?
Correct, but if I can articulate why, the synthetic narcotics,
You don't object to this line of questioning for outside the scope.
So beyond the scope of the questions sustained.
I want to go back to your initial observations of Mr. Francois in the back of the residence of Whistler's Cove, right?
yes,
Now, when you observed the subjects in the vehicle and Mr. Francois and another male in the back of the parking lot, no one was committing a crime, correct?
that's correct,
And you did not have reasonable suspicion that a crime had been committed, correct?
correct,
And you did not have reasonable suspicion that a crime was being committed, correct?
correct,
And you also did not have reasonable suspicion that a crime was about to be committed, correct?
correct,
So at that point, it'd be fair to say there was no probable cause or reasonable suspicion until you drove up to Mr. Francois, correct?
right,
Okay. Now, you had no idea that that was Mr. Francois until you actually approached Mr. Francois and asked for his identification, correct?
I had a pretty good idea as I testified earlier,
But you weren't sure, correct?
correct,
Mr. Francois doesn't have any outstanding warrants, or there wasn't a call looking for Mr. Francois or anything along those lines, correct? You
Not
were
at that
not,
time.
you were not investigating Mr. Francois from a prior crime, correct?
correct.
So there was no need for you to try to apprehend Mr. Francois.
Apprehend,
Yes, to go up to Mr. Francois and approach Mr. Francois. There was nothing from a prior investigation.
the intent there, sir, was an encounter, not an apprehension.
Okay. There were no prior facts before December 11th, 2019 that required you to go and approach Mr. Francois. There was nothing that you were trying to inquire about previous behavior, correct?
If you're asking if he was a wanted subject, if there was a bolo out on him at that time, no.
Okay. Now, Mr. Francois did not run away from you, correct?
Correct.
And did not try to evade you.
No, sir.
And in fact, you drove over concrete parking stops, correct? To go follow Mr. Francois, correct?
Correct.
And you drove over a patch of grass,
Yes,
and then you proceeded to drive down a pedestrian pathway. Is that correct?
correct.
And that pathway is not utilized for vehicle traffic, is that correct?
That pathway is utilized for official vehicles, sir.
For official vehicles?
Yes, sir.
Okay. And a normal human being, such as Mr. Francois, would never realize that someone's supposed to be driving on that pathway, is that correct? That information is subject to the sheriff's office. It's not standard knowledge that a vehicle should be driving on a pedestrian pathway, is that accurate?
Not sure if I understand your question at this time. It's rather broad, sir,
Okay. The pathway is enclosed with two chain link fences on each side, correct?
on each side, correct.
And it's a narrow pathway that is made for pedestrians to walk on, correct?
Pedestrians and bicycles, yes.
And those chain link fences are at least 8 feet in height, is that correct?
Closer to 6,
Okay. And in order for you to drive on that pathway, only a portion of your vehicle would be driving on that pathway. Additionally, the other side of your vehicle would be driving through the grass, is that correct?
depending on where any pedestrian or object would be, yes.
Okay, well, in this video here, you had to drive partially on the grass and partially on the walkway, is that accurate?
That's correct.
Okay. And Mr. Francois would not be prohibited to drive his vehicle on that pathway, is that correct?
He would be.
He can drive a car on
No,
that?
he would be prohibited. Would
Okay,
be.
prohibited. Now, Mr. Francois was not trespassed leading up to December 11th of 2019 from Whistler's Cove, is that correct?
That's correct.
And in fact, your prior testimony was that you've been instructed to trespass individuals from Whistler's Cove, is that correct?
Non-residents unaccompanied by residents, et cetera, in Whistler's Cove.
And you would agree that trespass is a civil action, correct?
That can eventually result in criminal action, yes.
Right, but initially it's a civil action.
Initially, it would be a written warning
Okay.
notifying the subject that they were not allowed back in the front.
Now, when you approached Mr. Francois in your vehicle, you were driving at a rate of speed to catch up to Mr. Francois, is that correct?
you're gonna catch up with somebody walking at a slow spot.
Okay,
But to use the term to catch up would indicate that I was speeding or coming in a fashion that would scare the average individual on that type of pathway.
okay, you had to,
I was operating the vehicle very slowly
okay,
and cautiously.
and then when you eventually approached Mr. Francois, you continued to follow Mr. Francois, correct?
We were actually adjoining each other.
Okay, which caused you to slow down, correct?
Yes,
And when you slowed down, it's your testimony that you detected a faint odor of marijuana at that point? Or
Yes,
was it? Okay. And you would not have stopped Mr. Francois based on that faint odor of marijuana at that point, is that correct?
I still would have had an encounter with him and asked him the same question I would have asked.
Okay. Do you recall providing a sworn testimony in a deposition back on October 21st of 2020?
Yes, sir, I have it.
And do you recall being asked if you would have stopped Mr. Francois based on a faint odor of...
Do you understand what page that is on?
Page 11. Now, draw your attention to line 13.
All right, so the full question is, okay, but he wasn't for that night. If he had turned around and started walking the other direction, would you have stopped him? May I continue?
Yes.
Okay. Would you have stopped him that way? Is that correct? Of course he was free to go. That's my answer to that.
Correct. Continue to read.
Okay? I had no reason to detain him. I had the faint smell of marijuana at that particular time. Would you like me to continue? Okay. And mine is a bit obliterated, sir. So some of the words I can't make out because I have it on the transcript. Thank you.
Sure.
So at that time, at that particular time, sir, if he had turned, I can't say I would have recklessly turned around and chased after him.
Okay, so based on that testimony, you would not have followed him based on the faint odor of marijuana that you had, correct?
Based upon that testimony, yes,
Okay.
in that situation.
Okay. So just so we're clear, when you were with Mr. Francois on the pathway before you stopped, you would have not have apprehended Mr. Francois due to the odor of marijuana, correct? That's what you just testified to.
I believe I testified when the state asked me that question, why I did not stop him at that particular time. And I believe articulated the current location of the interaction. It wouldn't have been wise to, because I'm in a narrow pathway. I didn't want the subject to feel threatened. And for my safety, I wanted to get out into an open area, much more lit and much more options for me to respond if in fact the subject was carrying a weapon.
If you just previously testified that the subject turned around and walked the other way, you would have not followed, correct?
No,
Okay, so the odor of marijuana at that point was not your point of contention.
I was not going to perform a reckless act based upon the faint smell of marijuana.
Okay. Now, when you came to the stop, you actually exited your vehicle, is that correct?
That's correct.
And you immediately asked Mr. Francois for his identification, is that correct?
Yes, sir, I believe so.
And you held on to his identification because you were running it through dispatch, is that accurate?
Yes, I believe so.
And you held on to his identification and never gave it back to Mr. Francois, correct?
He eventually did get back.
Before the arrest, correct?
Correct.
So he did not receive his identification back until after he was placed in handcuffs.
Yes, sir.
Okay. Now, you made a statement on the video that strike that question. You received a phone call from one of your colleagues, is that correct on the video?
Yes, sir.
And you indicated that you're going to stop out at this point, correct?
Yes,
And you indicated that you're going to essentially address Mr. Francois, correct?
I was going to address the male subject walking on the pathway.
Okay. And when you said you were going to call out the stop, you referred to 13 Papa, is that correct?
That's correct.
And that is code for a suspicious person, correct?
Yes, sir.
And then you also call out a 1014, that's for backup, correct?
That's correct.
This is all before addressing the marijuana call, correct?
This is
All before the LAP, before you confront Mr. Francois with the odor of marijuana.
I called out the 13 Papa, and then subsequently, at some point, I did radio for the 1014 to backup.
Okay,
At what point exactly in the interaction? It was at the onset, but I'm not going to say it was before or after I asked him for a marijuana count.
okay, well, it's on the video, correct?
It is.
Okay, and when you call it a 13 Papa, that's a suspicious person, not a drug activity concern.
Correct.
So at no point prior to did you call out that you were concerned about a signal 50, which would be a drug investigation?
Well, first of all, it's my
The answer is yes or
preference.
no, sir. Did you call out a signal 50?
No, I did not.
Okay, and signal 50, just so we're clear, is for drug activity, correct?
Drug case.
Drug case, okay. Now, once you received the identification from Mr. Francois, you were aware of where he lived, correct?
Where he lived?
Where he resided?
Yes.
Okay, and he resided in the neighborhood where he was walking, correct?
We believed he lived in Naples, Manor.
Okay. Do you recall the address on his driver's license?
No, sir.
Do you recall the address that you used to put into the booking sheet?
I can refer to the booking sheet,
Okay, please take a moment.
but I believe it's on Schultz.
Okay, and Schultz is within the direction of where Mr. Francois was walking, is that correct?
That's correct.
It's
Naples,
only a
Manor.
few blocks away from where Mr. Francois was stopped on this video, correct?
I would say a little bit more than a few blocks.
Okay, well, when you initially received Mr. Francois' identification, there's nothing that rose to your suspicion of why he was in the neighborhood, correct? Meaning knowing that he lives in that vicinity of where he's at.
My suspicion and reason to have an encounter with him, sir, is his location in Whistler's Cove, not a place of his residence.
Okay, well, Mr. Francois' residence is approximately 9 blocks away from Whistler's Cove, correct?
I believe so. I'm not going to give an opinion either way on the exact distance.
Well, you previously testified you're familiar with the area.
Yes, I am.
Okay, and you're not familiar with where Schultz is?
Yes, I am.
Okay, so it's within the same vicinity, is that correct?
Correct. You use a measured term to distinguish the distance, sir, not the vicinity.
Now, Mr. Francois seems to ask you a few times why you're being stopped. You recall that on the video?
Oh, yes.
Okay, and specifically about 3.5 minutes into the video is when the first question was from Mr. Francois, why am I being stopped? You recall that?
Oh, there was a couple times he asked.
Okay, and the first time first time Mr. Francois asked you, you did not respond, correct?
I believe the first time he asked, I responded, hold on, because I had to call stop.
Okay.
Okay.
Once you called the stop bell, did you tell Mr. Francois why he was being stopped?
When he asked again,
The second time?
the second time,
Okay,
I said, I said, one. I gave him the situation that I seen at Whistler's Cove. Before I could get into the second reason, which eventually I did later, Mr. Francois decided to go on a oration as to it was illegal, for whatever reason, I just let him vent.
okay. Mr. Francois was never physically resistant with you, correct?
Oh, no.
In fact, he was calling you sir and complying with your request, is that correct?
Yes, for the most part.
Okay. And just so we're clear, the first time Mr. Francois asked why he was being stopped, you did not respond because you were calling in, correct?
I said, 1 second. It wasn't like it. I ignored his request.
And then approximately seven minutes into the video, Mr. Francois again is saying that this is illegal, that you're stopping him, correct?
He was saying that over the phone.
Okay, but you heard him say that, correct?
Yes.
And you never responded and explained to Mr. Francois why he was being stopped, correct?
It wasn't directed at me.
Okay. Neither time you told Mr. Francois mention anything about marijuana, correct? Being concerned about him possessing marijuana.
As I said, the first time is when I asked him, hold on. The second time, my response started with, first. Then I articulated what I seen at Whistler's Cove. And then Mr. Francois decided to vent. I let him do it. And then did not immediately say anything during that interaction about the suspicion of marijuana.
So the first time that Mr. Francois asked why he was being stopped, did you ever tell him he was free to leave?
Did I ever tell him it was? No, I did not tell him.
At any point did you tell Mr. Francois he was free to leave?
Frankly, based upon my suspicions, I didn't have to.
Okay,
I did tell him officially he was detained once I placed handcuffs on him.
okay. But leading up to the handcuffs, you had no idea Mr. Francois had hemp or marijuana, is that correct?
No. Handcuffs were placed on after the verification of the marijuana.
Okay, thank you. And nothing further.
Redirect?
So you were cut off and you're trying to answer, the defense counsel had asked you about, the call out for signal fatigue, which was a drug case, and you were trying to respond to that. Is there a reason why that you didn't do that?
Well, the initial call was a suspicious person. If something leads into, whether it be a narcotics case or we discovered some stolen property, et cetera, that's generally changed either much later or in fact while the arrest report is being typed in. The other thing that I wanted to ask or answer is that at that point I did smell the aroma of marijuana, but could I articulate and sustain that it was in fact a drug case? Prior to my investigation, I couldn't, because we didn't verify the medical marijuana pad, the marijuana or suspect marijuana wasn't tested, and that was prior to, and that's when he was advised he was arrested, when the package of synthetic THC product was pulled out. That's an automatic. In my training and experience, that's an automatic. Yeah, you're not supposed to have it, you're under arrest.
And is that because synthetic marijuana is not legal here in Florida?
That's correct. I believe it's classified as a felon.
Okay. In addition to that, the defense counsel asked you about holding on to the ID in regards to not giving it back to the defendant right away. Was that done because of the fact that you stated earlier you were running the ID for the medical marijuana card?
Yes, that's, I also being able to be heard on the audio video.
Okay. And as we saw on the video, and as you testified earlier, when you first smelled the odor of marijuana, you stated at that time you decided that for different reasons you were going to wait until you were in a more well-lit area before you stepped out with the defendant, correct?
That's correct.
And you didn't walk him in when you came around and pulled out onto the road, correct?
Correct.
And at that point, as I recall, I believe you said that at that point, the defendant actually approached you.
Yes, he did.
Is that correct? So you did not detain him at that point. He actually came forward to you.
Correct. He continued walking towards my direction.
And as I recall, you testified at that point, you smelled the odor of marijuana even stronger at that point. Is that correct?
That's correct.
And then at that point, do you believe you would have probable cause to do a search?
Yes.
And the question.
Anything else?
Very brief follow-up.
Okay.
Now, sir, you indicated that my client walked toward you, is that correct?
That's correct.
And that's because you pulled forward past where the school entrance is, correct?
I went forward of the walkway. So once the walkway ends, if I can continue, it comes into the main entry area for Parkside Elementary.
So Mr. Francois had two choices, either turn around, go the other direction, or continue to walk forward. Is that
Yes,
correct?
sir.
Okay, so that's the reason why he walked toward you, because he was walking forward in the direction of the path, correct?
He was walking forward.
Okay, because you were ahead of him, correct?
Yes.
All right. And that's when you asked for his identification. You stepped out of your car and you gave him a command, may I have your identification?
Yes, sir.
Correct? Now, you almost immediately called in Mr. Francois' credentials to dispatch, correct?
Yes.
Once that information was called into dispatch, there was no reason for you to retain the driver's license at that point, correct? All the information had already been disclosed to dispatch.
Custom and practice, I hold on to someone's ID until we're done.
Okay.
Even during the traffic stop, sir.
But there was no reason for you to hold on to the license to divulge the information to dispatch, correct? The information had already been disclosed.
All right, information already been passed on.
Okay, so nothing in furtherance of your investigation required you to hold on to it other than your own personal practice.
I don't know how to respond to that, sir.
Okay, nothing further.
Ms. Wilson?
Nothing was said.
Does the witness need to remain for either side?
I don't need the witness, sir.
All right, thank you, officer. You step down.
Thank you.
Counsel, we have, for various reasons, exceeded a lot of time. I do have a couple of cases that have arrived that were here for plea. How much additional time in order to complete this?
I'm going to be brief. I have a few cases I'd like to submit to the court, and my closing argument will be a few minutes. We can address the pleas if we need to.
I think what I'd like to do is to address the pleas that were scheduled at 3,
Sure.
and then we'll come back and see what time we have left, if you can be available.
And Your Honor, if we may start with Mr. Maresca's plea first, and may I go ahead and place the
Yes.
objection?
No objection.
So that I can run out and get the people to my plea. So it's longer than I expected. And he states exhibit. Thank you. And Your Honor, may I get excused for?
Yes. So are we going to address Mr. Sizemore's case first, I believe?
Yes.
All right. 16 CF 934, State v. Sizemore. Mr. Brown for the defense, Mr. Maresca for the state. Are we here for a plea agreement?
I believe so, Judge.
All right, we'll need, whenever the bailiffs are ready to bring on Mr. Sizemore.
Good afternoon, Your Honor.
Greetings. Mr. Sizemore is now present. Hello.
Mr. Sizemore's previously reviewed a plea form, but I'm having him physically sign this out in court. Oh, you can do stuff too fast and stuff. That you don't need to sign, that's what you. You want him to stand for this, Your Honor?
No, that's okay. You can remain seated.
Your Honor, before the court, good record here, Ryan Sizemore, case 16-934 CF. I am Chris Brown, his attorney. At this time, we're before the court, subject to the court's approval, because Mr. Sizemore would like to withdraw his previous center plea of not guilty to counts 6 and 7 of the state's information, and enter a plea of guilty to those charges. And specifically for the record, those charges are lewd or lascivious battery. Those are second-degree felonies, punishable by 15 years of Florida State prison each. Counts 1 through 5 and count 8, I expect the state will give it no possibility of the court's Eric, we have one more clarified detail.
Yes.
Thank you on that. I have made an error, and I have no to speak, Mr. President. Here I just spoke of adjusting the plea form, not the plea form, but my worksheet accordingly or manipulate. Those three counts, are those counts 1 through 5 relating to possession of images, multi-sex offenses of the 3rd degree. We would be entering pleas on those, as well as guilty.
So the guilty pleas will be on 1 through 5 as well as 6 and 7.
1 through, yes, so, yeah, put it simpler, 1 through 7. The state's no question, 8. My apologies, I tried to pull a fast one on Mr. Marasco. Okay, so I have that part right now. So the state prison part of this sentence, again, subject to your Honor's approval, would be 5 years. That would be the max on counts 1 through 5. Of course, it's not the max on 6 and 7. It would be 5 years concurrent on all 7 counts. Now, on 6 and 7, which are, of course, higher degree felonies, that will be followed by 10 years of sex offender probation. Counts 1 through 5 is just 5 straight years, because they're 3rd degrees. The agreement on credit for time served is that Mr. Seifel will be given credit from the date of February 12th of 2019 as the date that this one was served on in the Department of Corrections. My math is 794 days, but I'm sure the jail will double check that. I was not in mathematics judge, but I think I'm right on that. Again, as I mentioned, the sex offender probation, I'm sure Mr. Marasco will put the terms on the record. I will say I previously discussed the terms of sex offender probation with Mr. Seifel. I will also note that Mr. Seifel has previously been on sex offender probation, so he is familiar with the concept of it and the strictures that he will impose upon. There will be no contact with the victims in this case. I don't know if the state wants to submit a separate order on that.
How many individuals?
Well, Judge, he was only actually charged with the one individual, the JR, actually in the information.
There's no contact with JR. And Judge, I do have to note something for the record regarding game time. It's not something we're asking the court to rule on. It's something Mr. Seifel is asking to look into, and I don't blame him. And it's something Mr. Marasco and I have had a detailed discussion about. The count involving JR or Jason Randall indicates a broad date range, and it's important because the statute relating to game time, Department of Corrections, sets that far at October 1st, 2014. It says any offenses after that date will not be game time. Mr. Marasco and I both believe that because the statute, because the time frame alleged in the information runs on both sides.
Well, actually, I looked at the instead. With that, before or after, but I mean, you're looking at 1 through 5 was the 1 year difference. I don't know where it's split at.
You know, I must have been looking at the first information. That actually helps. Okay, so the information, so that's the information dated with.
It's the information dated. And Judge, for the record, we did talk about this, even though we're having some.
Yeah, we're talking.
It seems like you're supplementing it awful lot.
It may not appear that we've talked about it, but we really have.
We're getting a bad start here, but we're going to pick up some momentum.
File.
Then one of those days.
April 1st, 2019.
You're filming it too?
This would be the information of April 1st, 2019, which only alleges regarding victim JR. And it alleges on or about June 17, 2014. So that may answer your question. So it specifically alleged the offenses in 6 and 7, June 17, 2014. So I've explained to Mr. Seifel, and either the court or the state will make any promises regarding game time that I can tell him definitively now. The Department of Corrections will see a record that reflects that before the October 1st, 2014.
Okay, none of that is to be noted by the clerk, is that right?
No, I think I'm just making it part of the record this plea because Mr. Sizemore and I have discussed, at least I've discussed with Mr. Maresca. But if the Department of Corrections disagrees, he'll have to contact me, I'll have to address it with them. But thank you for letting me make the record on that, Judge. The other terms and conditions of the plea are the court costs, $100 cost of prosecution, again, no contact with JR, and then, of course, the entire terms of the sex offender probation order and sex offender probation as required by the statute, which he's familiar with, which will follow the 5-year sentence. I do have here a plea of guilty signed by Mr. Sizemore at both places that he's read and he understood. I have part of my handwriting manuscript plus the corrections, but I do have a plea agreement worksheet as well, but I approach.
What are the court costs, Madam Clerk?
$1,472.
And is there any investigative costs, Mr. Maresco?
Judge, there should be, but I never got an affidavit, so we're not seeking.
So those are not sought at this time?
No, I don't have that.
And restitution involved?
I don't believe there is. We asked that be ordered in an abundance of caution. I don't believe there is any restitution.
That's no objection, Judge. There's nothing in discovery about it, but I agree with the state that the court should order it in this case and preserve.
Is there any objection or request for hearing on any monetary amount?
No, sir.
Any other clarifications or terms from the state?
I don't think so.
Madam Clerk, anything you wish to have addressed?
I just want to make sure counts 1 through 5, that's the only term sentence we did in. And
The Department of Corrections concurrent sentences are on 1 through 5.
Right, in the probationary.
it's just on 6 and 7, right?
There is the sex offender probation is concurrent, yes.
But actually, 1 through 7 all have concurrent DOC incarceration.
No, Judge, just
No?
1 through 5 is the.
Okay.
Is the prison terms, and 6 and 7 are concurrent 10-year probation.
But consecutive, obviously, to the incarceration.
The 1 through 5, the 5 years is concurrent to each other to the prison.
Yes.
The sex offender probation, which is 6 and 7, are concurrent to each other, but obviously consecutive to the prison.
Consecutive, right, so 5 years, the way I stated it, I think I stated it correctly, is 1 through 7, 5 years on each count concurrent with each other, but 6 and 7 followed by consecutive terms of 10 through 6,
Right, well,
which are concurrent with each other.
Right, and there's no prison on 6 and 7, just the probation.
Now, what's interesting about that is that would mean that incarceration is being ordered on the lesser felonies, but not on the greater.
Kind of.
So is that the intent of the parties?
Well, the intent is so that we have 10 years of sex offender probation to follow, and if for some reason he messes up, we're not going to be limited by the fact that he's getting credit for 5 years of the sentence that he could get 15 years.
So there is a method to the prosecution's.
Judge, there always is.
Okay.
It may not seem right, but actually, I think it's a character.
I often try to figure out what Mr. West is, but eventually it makes sense. So yes, Mr. Sizemore indicated he understands that, although of course he still would get credit for the time in each count. I believe he would get it 6 to 7 if there was a violation.
I believe the state presented me with authority very recently that indicates not.
I don't
not
think
that
that would happen.
Because they're consecutive to one.
Because the probation is consecutive to the prison, he's getting no prison on those counts. He would get credit for the amount of time he's been in our jail on those counts. But the actual going to prison on 67, he wouldn't get credit for that, but he would get credit for this amount of time he's been in prison on these charges.
On the 1 through 5. Thank you for
Sure.
I apologize, Your Honor. I want to make sure that I'm not saying anything incorrect.
This time he served all the time up to today, he'll get credit.
Right.
If he was to violate them. Hopefully, we're not even going to be there.
So my earlier confusion was correct. These are specific, this is specific age, this is for age rate.
Right.
This is both before and after.
Right. So that's still an issue.
I want to go back to what I originally said. So
Yeah.
the counts that have the prison sentence 1 through 5. If you indicate a range from June of 14 to June of 15, again, we're not asking for the court to rule on, but Mr. Secretary, it's gonna show on both sides. My belief, and Mr. Mareska's belief, is the department will probably interpret that in your favor. However, if that doesn't happen, you understand, or would you still be entering that plea? I understand that's not a guarantee, and we're hoping that happens. If it doesn't, contact me, but would you still, if you have to allow me entering the plea today, knowing that that's kind of ambiguous?
I do understand that there is some ambiguity in that, so I am going to still enter this plea today.
Now, Mr. Sizemore, this has gotten a little bit complicated today. Are you comfortable making these decisions on the spot, or do you want to come back on another occasion, have time to speak with him in private about all of this?
I understand everything that we have discussed up to this point. I've understood everything that's going on here today.
And you want to go forward as opposed to deferring this any further? All right. Now, again, as I have heard the state's comments, the one element of risk with this particular setup of the plea agreement for you is that, and maybe it'll never happen, but should you have a proven violation of supervision on the sex offender probation, the state would then likely be arguing that if there were a prison sentence on that violation, or any incarcerative sentence on that violation, that those two counts, 6 and 7, that are just probation, would not have any credit for prior prison.
I understand that.
Okay. So he appears to understand how that might work if it were applicable. Any additional comments before we do the plea college?
I think we do have it right, and I do apologize. I can say this, if anything was probably, if any confusion there was probably caused by over communication, not lack of. We spent a tremendous amount of time trying to work out a solution that was acceptable to both sides, the victim, and how to structure things. So we had multiple messages back and forth about how to do executive concurrent. And so I apologize for it being a little jumbled today, but I think we do have everything straight.
And Mr. Sizemore, you believe this agreement is in your best interest as opposed to defending against these charges at trial?
Yes, sir.
And you don't need additional time to speak privately with Mr. Brown about any of this?
No, sir.
Mr. Mareska, did law enforcement or any alleged victim have any opposition to the plea agreement?
Well, Judge, we've had discussions with the named victim in this case, and I've received differing viewpoints on this because this is a below guideline sentence. But ultimately, the victim indicated he did not want to have to go through a trial.
Okay. Did this alleged victim wish to present any victim impact testimony either in person or through the state?
I don't believe so. They were told they had that ability to do that, and I don't believe they.
Anything else preliminary to the plea colloquy?
I don't think so. Judge.
Very well.
I would add one more thing for the record. Judge, you did very patient. I knew you were other things to do here.
Yeah, that's starting to run out now, Mr. Brown.
This is the last thing I want to add that we can just talk about. At some point, we will get to the Civil Commitment Act, and Mr. Seidler's warnings. Obviously, it's important in this type of case to go through that, and especially important in this case because, as we know, the score sheet he has a prior sex offense. So what I did in this case, without disclosing the results, is I had a Dr. Cerrone, who is a sex offender counselor, who also gives opinion on the issue of civil commitment. Actually researched Mr. Seidler's case, and he rendered us an opinion for the file of Mr. Seidler's copy. Then again, without going into the results, but he had some thoughts on the potentiality of that down the road. So Mr. Seidler, I tried to make sure he's as well informed as he could be about.
And when you said for the file, you mean for the defense file, not
For
for
my
the court
file,
file?
and of course, Mr.
Okay.
Seidler had helped.
Then at this,
That's the only other thing I want to put on record.
Mr. Seidler, if you just remain seated, raise your right hand, be sworn by the clerk.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, my lawyer hand. Please answer the state's questions.
Hey, sir, please state your name for the record.
Ryan Edward Sizemore,
Hey, what is your date of birth?
December 2nd, 1988.
And how far have you gone to school?
I have an associate in arts degree.
Okay. And it's my understanding you wish to plead guilty to the following charges. 5 counts of possession of child pornography, which are third-degree felony, punishable by up to 5 years incarceration, and 2 counts of lewd and lascivious battery, which are second-degree felonies, punishable by up to 15 years incarceration each. Is that correct?
Yes.
All right. What did you handle this one? All right. Sir. Did you read over the plea form?
Yes, sir, I did.
Okay. You understand the various rights you're giving up by entering this plea?
Yes, I did.
Is this your signature and second page?
Yes, it is.
All right. Now, are you currently under the influence of any drugs or intoxicants?
No, I'm not.
Have you ever been treated for mental illness in the past?
Depression.
Okay. Are you receiving any medication for that?
I am currently, I'm on Prozac and Ramiro.
Okay. And does that affect your ability to understand what we're doing here?
No, it does not.
Okay. You're comfortable going forward that you're
Yes.
All right. Now, you've heard what the plea agreement is. Is that your understanding of the plea agreement?
That is my understanding.
Okay. Any questions about that?
No question.
All right. Now, have you told your attorney everything you know about the case?
Yes, I have.
Are you satisfied with the services of your attorney?
Yes, I am.
Okay. And you understand by entering this plea, I'm just going to kind of go through some of the rights you're doing by entering this plea. You're giving up the right to make statements in the case against you beyond a reasonable doubt, the right to have your attorney cross-examine the state's witnesses, the right to know witnesses on your own behalf, the right to have your attorney bring in any kind of evidence that he may want to bring in, the right to either testify or not testify. You understand that?
I do understand that.
Okay. Now, I got to go into a couple other things too. We were talking a little bit about game time in this situation. Now, you understand that we've had a lot of talk about this game time, and while we believe that where the sentencing point is, that my understanding from your counselor is that you may benefit from certain game time rules or regulations at the time of the offense. You understand that if for some reason it doesn't go your way, that's not going to be a basis to withdraw your plea.
I do understand.
I mean, you may try to litigate it with either the Department of Corrections or with the trial court, but you're not going to be able to withdraw your plea based upon that.
I understand.
So even though we expect you're going to get game time, there's always a possibility you might not get any.
I understand that game time is solely at the discretion of the Department of Corrections.
Okay, very good. And does anybody use any threats, promise, or force to get you into this plea?
No.
You feel like things please in your best interest?
I do.
Okay. Now, you understand if you're not a U.S. citizen, you get deported as a result of this plea.
I do understand that.
Now, also because of the charge, you understand that the Sexually Violent Predator Act.
I do understand.
Okay, did you have discussions with your attorney?
I have.
Okay. You understand that if for some reason they make a determination that you may qualify as a sexually violent predator, they may request the state attorney's office at the end of your sentence to file a petition, and then there could potentially be a civil hearing. You understand that?
I do understand.
And your attorney put on the record that you've had an expert do an evaluation and do a report for you.
I did.
And I'm not going to ask you what that is, but you understand that whatever that report is or whatever that recommendation is, that may or may not happen with the Department of Corrections by the time you complete your sentence. You understand that?
I do understand.
And if for some reason, and I'm just hypothetically, if you were being told by this expert, I don't think they're going to file a petition for sexually violent predator. If for some reason the state does, that's not going to be a basis to withdraw your plea.
I understand.
Any questions about that?
No.
All right. Mr. Brown, as a defense attorney, in this case, you stipulate there is a factual basis for this plea been utilized properly in Collier County. There is no DNA evidence in this case. I agree. You also understand that and I don't think I've shown you the amended source sheet without count A, that the amended source sheet, I guess I should show you this, of 330 points with the lowest permissible of 226.5 months is accurate.
I think it is below this Jones. I have reviewed that with Mr. Seifel. He'd seen the previous copy of that amendment. I just want to make sure he saw that copy.
And sir, the only difference is the amendment is I'm taking off county.
Correct.
Which lowers your actual, switching. And Mr. Brown, as a defense attorney, could you also stipulate this is a negotiated plea agreement?
Yes, it is, of course, negotiated.
Your Honor, at this time, Mr. Sizemore, do you have any questions about this?
No, I don't.
Okay, Your Honor, at this time, we come to the plea report.
Any additional defense comment or request?
No, sir. As you said, I've reached my patience limit. Joking aside, I do not have anything more to say.
Defense waives any pre-sentence investigation?
We do.
Based on the plea agreement, plea colloquy, the pleas of guilty, and the arrest affidavit facts in support thereof, court accepts the plea agreement. Counts 1 through 5 will have sentences agreed of concurrent between these counts of 5 years Department of Corrections. Credit from February 11 of 2019, subject to verification by the jail, but believed to be 794 days.
Yes, I believe February 12th.
From what date?
I believe February 12th.
12, all right. As to counts 6 and 7, there will be 10-year sex offender probation, though that supervision is concurrent between each of those counts, but is also consecutive to counts 1 through 5. There is a no contact order as announced. Court costs $1,472, prosecution $100, order and reserved with the right to hearing if the state requests any restitution. Monetary amounts to be referred to collection. Any other terms for the parties or the clerk?
Judge, we just have to make certain findings that at the time of the offense, the defendant, I believe, was 29, the victim is 15, and it involved unclothed genital contact.
Any questions from the clerk? Any?
We reserve the restitution on 6 and 7.
Yes.
Is it for all counts or just 6 and 7?
Yeah, just 6 and 7, we count 1 through 5 as child, possession of child.
All right. Any other defense clarification or request?
There you are.
The plea agreement is approved. Thank you for resolving your case.
Thank you, Your Honor. It's serious. Thanks for your patience.
Very well.
This was a tricky one. Really small, as you can tell.
5 years DOC. Correct. This was, Mr. Maresca, below or at guidelines?
It's a below guidelines.
Below? All right.
Yes.
Okay, we'll next do the Mesa Martinez case, I believe.
That's correct.
Okay, one moment. Score sheet, Madam Clerk. Greetings. Ms. Wilson, let me ask you before we start this case, based on what you anticipate to be the time you need on the suppression motion, what guess would you have as far as total time for that for both sides?
An argument quite well for both sides. I'd say no more than half an hour. I just don't know how much time it would take Mr. Bergeron. Myself, I could be done at 10, 15 minutes.
Yeah.
It's more.
Did Mr. Verderamo leave for another location? Let me have him come in a moment. Okay, Mr. Verderamo, it's almost as if you could sense me. I just need to do this plea agreement, but I wanted to get an idea of what's the total time you need for you and the state to finish the suppression motion.
I need 10 minutes.
Let's say between the two of us, 20, 30 minutes max.
So there's no additional evidence to be presented?
No, it's just argument on my behalf.
and the parties believe each 10 minutes per side. I don't want to rush you. The other option we have is to come back on Monday sometime.
I think we can get it done.
Yeah, I mean, most would be is if the court has some questions to ask,
Right.
for another 2 minutes, but I said 30 minutes now.
All right, and we can finish today, I think.
Thank you.
All right. So let me turn to this case. This is Mr. Calvo on behalf of Mr. Meza Martinez. Good evening, gentlemen. Ms. Wilson for the state. Mr. Padro is the interpreter and will be sworn at this time.
Do you swear or affirm that the interpretation you give from English to Spanish and from Spanish to English should be a true and accurate interpretation?
I do, Jorge Padron, for the interpreter.
All right, thank you for your assistance.
You're welcome, Your Honor.
And Mr. Meza Martinez, do you understand the interpreter in Spanish?
Yes,
Is Spanish your primary language?
yes,
And you're able to hear adequately with the device?
yes.
All right, thank you. You may be seated. And counsel, let's proceed slowly for the interpreter.
Your Honor, the defendant is going to plead to the lesser included charge of plain roof, still 316.1935, subsection 2. There will be an adjudication, 2 years of probation, 75 hours of community service hours, and it looks like Mr. Cutler had offered that he provided out $2 an hour, is that correct?
That's correct.
And then court cost of prosecution, $297, cost investigation to the Colorado County Sheriff's Office, and order of reserve on any restitution.
Mr. Calvo, any clarifications?
No, Your Honor, that's correct.
What are the court costs, Madam Clerk?
$485.
Is there any objection or request for hearing on monetary amounts?
No objection.
The parties agree that the community service may either be performed or be bought out at the agreed rate.
Yes.
Yes, Your Honor, Mr. Cutler did relay that, so I cannot object to this one.
Reporting to supervision in Collier County today.
Yes.
Is there a transfer needed?
We'd ask that he be allowed to report here and then transfer to Lee if that's okay.
So Mr. Meza Martinez to report today after leaving court in Collier. The court will authorize immediate transfer to Lee County.
And the state would agree that he can apply for early term of probation after 1.5 months. If there's no violations, then it's completed everything.
Any other clarifications by the parties or the clerk? And sir, you understand and accept these terms?
Yes,
Do you prefer this instead of the trial?
yes,
Please raise your right hand, be sworn by the clerk.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
yes.
Thank you. May I lower your hand? Please answer the state's questions.
And actually, Your Honor, I noticed that there was not a term that's actually required by statute, and that's a 1-year driver's license verification. We did discuss that, so they are aware that that is required by statute.
Yeah, I don't know if the court has to impose that. I believe DMV does it automatically, unfortunately.
It is in statute.
Okay, and what is the agreement, if any, of the parties on that term?
We discussed before, and that is a requirement that a driver's license can be suspended. I did agree to this, given the lesser included, but I told him it would still be an investigation of the driver's license.
So the defense agrees that the suspension must be ordered by the court by the plea agreement?
Because that's what we have to do. And I believe it's statutory.
Yeah, I don't think it
A
matters.
little more slowly, please.
I don't believe it matters. That's an administrative, even if the court doesn't do it, DMV's gonna do it anyway.
Well, the question though is the plea agreement requiring it?
I would say that it does, Your Honor. And in addition, there is a fact that you might not be able to get a driver's license one way or another as a business purpose or hardship. But I do not have an objection if he is able to get one.
So the defense agrees to the imposition of 1-year driver license suspension with the additional language that the court authorizes issuance of a business purpose or hardship license.
Yes.
That will be included. Please proceed.
Sir, would you please state your full name for the record?
Previous case, quote, on the side there.
Luis Carlos Mesa
That was all
Martinez,
communication.
And what is your date of birth?
16th of June of 2000.
And the last four digits of your social security number?
I don't remember that.
Okay. And how, have you ever been known by any other name or alias?
No,
Where were you born?
in Honduras.
How far did you go to school?
Senior in high school?
And can you read, write, and understand the Spanish language?
Yes,
There is an interpreter present with you who's been translating directly to you, correct?
yes.
And what language has he been speaking to you?
Spanish,
And do you understand English?
yes.
Are you understanding drugs or alcohol?
No,
Are you taking any medication?
no,
Are you suffering from a mental condition or disorder?
no,
Do you understand why we're here today?
yes,
You're charged with fleeing and looting. The lesser included charge is fleeing and looting, which is a third-degree felony, punishable by up to 5 years for state prison. So that charge has which is plea.
guilty.
And you understand as a result of this plea that you will lose your driving privileges for 1 year.
Yes,
For clarification, is the plea guilty or no contest?
okay, no contest.
And let me just ask the state, is there any known opposition to the plea agreement from law enforcement?
No.
Thank you. Please continue.
And I was gonna ask you how you want to plead it. It was just on that. Do you understand that by giving this plea, you're waiving your right to have a jury trial?
Yes,
The right to have that jury determine whether you're guilty or innocent?
yes,
The right to see and hear the state's witnesses testify, have your attorney question those witnesses?
yes,
The right to see and your own witnesses and submit evidence on their own behalf?
yes,
And the right to testify in your own defense or choose to remain silent?
yes,
You also have the right to make the state prove this charge beyond a reasonable doubt.
okay,
So you understand all those rights were given up by your plea today?
yes,
Counsel Hayes, please repeat the matter. Sir, do you understand that you're giving up your right to appeal on all grounds except whether the court can enter this sentence today?
yes,
I'm showing you what's been three-page score sheet. Have you had a chance to go over this document with your attorney?
yes,
It shows you have no criminal history and that you scored 16 points with a maximum sentence of 5 years and 4 state prison. Is that correct?
yes,
I'm also going to show you a 2-page duty form, front back. Now it is in English. Did you have a chance to go over this form with your attorney?
yes,
And did he explain it to you in the Spanish language?
yes,
And he went over all the rights that you're giving up that's contained on this form?
yes,
And did you understand?
yes,
Do you have any additional questions you want to ask your attorney in regards to this form?
No.
And did you sign the back of this plea form?
Yes.
And is that your signature right here?
Yes.
And you sign that to indicate that you're in agreement with all the terms and conditions of this plea and that you understand the plea form?
Yes.
And did you sign right here on the back of the form?
Yes.
And you sign there to indicate that you are satisfied with your attorney?
Yes.
I think the one is contained in the plea form of what we discussed on the record. Has anyone promised you anything in exchange for this plea?
No.
Are you entering this plea at your own free will?
Yes.
Are you being forced or threatened by them?
No.
Are you pleading because given your option, you believe this plea is in your best interest?
Yes.
You understand that you're going on probation, and if you violated the terms of your probation, and if the state was able to prove a willful and substantial violation, you could receive up to 5 years in court state prison.
Yes.
And you also understand that, there's no guarantee that you will be able to terminate your probation early.
Okay.
Are you satisfied with the advice of counsel, Mr.
Yes.
Have you done everything you asked and answered all your questions?
Yes.
Counsel, have you reviewed all discovery and evidence in this case of your client? Sir, is there anything you wanted to review involving this case that you did not get a chance to review?
No.
Your Honor, I'm not aware of the physical evidence that can be tested for DNA. Counsel, do you agree? Sir, do you understand that if you are not a U.S. citizen, you may be subjected to removal or deportation as a result of this plea?
Yes.
And you understand that if you are deported as a result of this case, it will not be a basis to withdraw this plea?
Yes.
Do you need any additional time to discuss this with your counsel?
No.
If this with your plea is a sexually violent offense or sexually motivated offense, or if you preach the indicator of such an offense, this plea may subject you to involuntary civil commitment.
Sorry, Your Honor.
A little more slowly?
Yes. Yes, it is.
This plea may subject you to involuntary civil commitment as a sexually violent predator upon completion of your sentence. Do you understand this point?
Okay. Yes.
Counsel, you stipulate that the basis of the plea?
Yes.
Your Honor, at this time, the state would ask the court to take judicial notice of the trial and state the plea.
Any other defense requests? Based on the plea agreement, the plea colloquy, the plea of no contest to the lesser charge, the court will approve the plea agreement. The plea is supported by the arrest affidavit facts. As agreed, adjudication of guilt on the lesser charge. As further agreed, 2 years regular supervision. Reporting in Collier County today. Immediate transfer of probation to Lee County is granted. May petition for early termination of supervision upon successful completion of conditions and at 1/2 of the term. 75 hours community service that may be bought out at defendant's option. 1 year driver license suspension, business purpose or hardship license authorized. Monetary amounts have been previously described. There is no objection, and they are ordered to be paid during supervision. Anything else for the clerk or the parties? And that is ordered and reserved on restitution. Thank you for resolving your case. Please step over here for the prints. And 5-minute break, and then we'll finish the Francois case.
All rise, or is it recess?
And we will keep it 5.
All right, you're on the clock.
Hey, what is my probation order?
What's that?
So, why I don't have my probation order?
Well, I gotta stay anyways. We'll explain something to you. Step over in the corner. Explain something.
He needs papers to go to probation.
Well, I'm gonna write it. Don't fix your mask, because they're gonna say, I don't understand what you're here, I think that we talked it. Still across the street, right? So they can, so we can, wait a minute. Still, Joe, is there? He told me to do it. Yeah. Well, then he can interrupt the guy. I'm not doing it. He told me. I'm not interrupting you. No, I'm not. Okay. You can interrupt the judge. That's why. I'm not interrupting somebody while I'm taking a plea. That's why I interrupt. I'm not interrupting nobody. If he wants to interrupt him, that's. Don't be wrong. You explain to him, we're not gonna be the ones to call on the carpet because we're interrupting somebody while they're listening to something. The buck stops right there. Then he can interrupt. Yeah. We can call him the carpet. That's the order right there. For me, he ain't like this, he can't argue this shit. He ain't used to being on the carpet. Choke yourself out. So you have the permission to do it. Well, guess what? It's not happening, then. I'm sorry. Okay. That was all relayed to me. Relayed to you. But you want to get an early start, you want to welcome through. Well, you guys have steak in my anyway, right? Sandwich? Yeah, no, it was ridiculous. You want that sandwich? No, I have a salad. Oh, come, that sandwich. Hold on, hold on. Go eat. Eat a protein drink or anything? Oh, or come on, what do you want? What's the one? Our time to do. By the court superior. It's not for a security issue. I know you are. Don't be cautious, stop all the way. Be there. He's not your boss. You're for security. You know. I don't. All right, Collier County Circuit Court back in session.
All right, we'll finish now on Mr. Francois' case. Welcome back. Please be seated. And I believe all of the evidence had been concluded.
Yes, that's correct.
All right, arguments of counsel beginning with the defense.
Thank you, Judge. There's been 4 cases in the line on, and the decision of the Court of Appeal as well, I think they can rely on all as well.
Thank you. Yes.
I didn't know you had that.
Thank you. Oh, I keep getting reminded of this decision.
Well, I'm not happy with this. Trust me. Not happy. I'll keep it brief. I'll go through my cases initially and I'll apply area. The 4 cases that I presented to Your Honor is the citation of the first case is Hillby State 39, 730, 37. And I remain seated.
Yes.
This is a situation where the officer did not observe anything that indicated that a crime action was occurred or about to occur. What's important to determine this is the case of the 3rd District, 2010. But in this situation, there was an officer that drove his patrol car a long way down a one-way road position directly in front of the defendant. Behind the car spotlight at a woman and the defendant. And another officer approached, and basically in the manner that they approached the defendant, essentially referred to the seizure of the individual's rights. The officer testified that the defendant in this case was free to decline the search and leave, although Hill felt that the officer did not have the right to search him. He emptied his pockets and he was searched. A little different than our fact pattern, but the holding in this case is important. At some point during the interaction, Mr. Hill, the defendant in this case, provided his identification. And it's important to point out from the holding in this case, the Florida Supreme Court has held that the retention of identification during the course of further interrogation or search certain factors whether a seizure has occurred. It's a reasonable person standard. And the court held in this case, Hill, standing in the shoes of the defendant, would not feel that he was free to leave and simply walk away from 4 officers who retained his driver's license and asked the question person. Additionally, it indicated that they did not have a well-founded articulate suspicion that Mr. Hill in this case was engaging in criminal activity to support a 14th Amendment interrogation and investigatory stop, being that there was no crime that occurred. Now, I can distinguish this. This is somewhat different because there was no odor alcohol, or excuse me, odor marijuana in conjunction. But it is initially factually applicable because there's no crime initially occurred. The manner that Deputy Sheriff Ramiro approach is not reasonable. He's driving on a path of a pedestrian path. He approaches and retains identification. Identification was not given back to Mr. Francois before he was placed under arrest, which is similar to the facts in this case. Now, addressing the Owens layer, which is the new opinion of the Second District Court of Appeals, that's the additional fact that it's not provided in the case. The Owens decision strictly towards vehicles. It deals with vehicles. It does not deal with pedestrians. And the Owens decision deals with the fact that the statute prohibits the possession, open possession, and/or consumption while operating a motor vehicle. We don't have a vehicle in this case. There was no issue. To point out, Deputy Scaduto's limits it to no training in detection of hemp versus not ruling out hemp until after Mr. Francois was placed under arrest. And I think that is the distinguishing factor of Owen in this case, is that it's a vehicle. And in reading the decision in Owen, and reading all the cases as well as the North case, it deals with probable cause or reasonable suspicion to get into the vehicle, to search the vehicle, with the concern that the person may be operating the vehicle while they're impaired. And it specifically states that no one in the Owen case is determined to make sure that this person was not recklessly driving the vehicle, which is specific to the facts in the Owen case, that the person was intoxicated while driving, and additionally, the Florida statute prohibits the consumption and/or open possession of prescription marijuana. This is a different fact pattern that a pedestrian walking down the street never ruled out hemp, and there's nothing illegal with walking down the street with the odor of marijuana and/or hemp, and that must be ruled out in order to take a beyond reasonable suspicion or probable cause. The next case I provided the court, which is the second district court of appeals court, which is Lane v. State, 145, 7/3, 940. This case deals with the premise of an 18-year-old individual high school student walking along the sidewalk. Deputies turned off his light after he concluded a traffic stop and approached the individual. At the hearing suppression hearing, the defendant in this case testified not clearly during the encounter and did not recover his identification after being released from the jail. Very similar to the fact pattern we have here. What's important to point out is Mr. Francois asked multiple times, and there was a testimony as well as on video, why am I being stopped, why am I being stopped? The initial time was never disclosed. The second time, there was a response, and it's important to note on video, you were in Whistler's Cove. There was no indication or anything about drug possession or an odor of marijuana. It was you were in Whistler's Cove. The officer's testimony is as until Mr. Francois was stopped at the entrance of the middle school, there was no crime being committed. It was not under investigation. There's nothing criminal about being in Whistler's Cove. Mr. Francois does not have to answer the questions to the officer why he was in Whistler's Cove. It's not relevant at that point because it was not under investigation of a crime. Where it switched from a consensual encounter to an investigatory stop was when the ID was given. Mr. Francois is asking, why am I being stopped multiple times? Never given or provided a specific answer related to drug investigation, which led to the drug investigation. Now, it's important to point out that, again, the Florida Supreme Court or the U.S. Supreme Court had dealt with the encounters and retaining individuals' identification travel documents, and they clearly indicated that the retention of identification in the course of an investigation or search, certain factors come into whether a seizure is taking place. And they found that in retaining individuals' identification for travel documents, switches from a consensual encounter to an investigatory stop. And you have to take the factors and the totality of the circumstances at play. And assessing what took place on the video as well as the testimony, Mr. Francois acquired multiple times and was never told he was free to leave. Now, the officer does not have to tell Mr. Francois he's free to leave, but it's clear he's questioning why are you stopping? One of the same. I don't want to be here at this point. He acquiesced to the officer's request. The Horn case, which is also a Southern District Court of Appeals opinion, 113 Southern 3rd 158, recent opinion from 2013, is also cited out of the Lane opinion. It holds for the same premise, but it's an individual that's walking on grass between a house and a road. The officer stops, asks questions. Now, this was a acquiescence, and this individual did allow the officer to search, but seizure is important, not the actual consent to search. What took place, would a reasonable person at the time that the officer is encountering the individual, a reasonable person would, based on the totality, would believe that they're no longer free to leave. In this case, this was a casual encounter. It ended once the officer asked for identification and then checked the warrant, more importantly, without returning the individual's license. And that's something that the Second District Court of Appeals held on as one of the main factors to consider in conjunction with other circumstances, which we have in Mr. Francois' case. The last case that I have is BG v. State, 213 Southern 3rd 1016. It's a case out of Charlotte County. The reason why I pulled this case is it holds for the same premise, but this is a number of individuals that are standing around with marijuana, and they determine that there is insufficient. Mere suspicion is insufficient for possession when there are multiple people standing around with an odor of marijuana. The reason why I pulled this out is the holding in this case is very important. It's the officer cannot justify detention after the facts based on the information gathered from the improper detention. I would submit to the court that when you watch the video and when you listen to the testimony, Ken was never addressed. The odor of marijuana really wasn't addressed until 5 minutes or so, 6 minutes or so into the actual detention, where it switched from the identification. And it's important to point out that that was never the contention. More of the contention was that you were in Whistler's Cove. And that's what the officer kept telling me. He finally told Mr. Francois why he being stopped. He said, because you were Whistler's Cove. That's not a crime. Additionally, whether the officer knew or not, he had a driver's license. He lived with the area. Mr. Francois lived in it. He was heading in the direction of his home. He was doing absolutely nothing wrong. He was up to the search. I submit to the court that we maintain, even with the odor, based on the officer's lack of training and experience with him, and his inability to question Mr. Francois prior to being arrested about him, believe that a full investigation was not concluded at that point prior to Mr. Francois being detained. The case law supports driver's license identification being held, and then subsequent facts after lead to an actual detention and switch from a central encounter based on the totality of the manner that he was approached. And again, applying the Owens case, I believe that the distinguishing factor is that Mr. Francois was on a pedestrian path, walking and not operating the vehicle. Based on that, we asked the motion to that.
So you believe the detention occurred at what point in Mr. Francois' timeline?
I believe the detention occurred at the time that his driver's license was handed to the deputy, and Mr. Francois says, "Why are you stopping?" And that's important because, one, he was not provided an answer. There was no discussion about an odor of marijuana, no discussion about a crime being committed. So it took place once the driver's license was given. Once the information was called in, there was no reason to retain the driver's license. And Mr. Francois clearly feels that he's not free to leave this. He's asking, why am I being stopped?
Now, your assertion also is that there was no reasonable suspicion of a crime at that point where the driver license was taken and retained?
That is correct.
Now, what about the testimony that in a high crime area, according to the witness, he observed a vehicle, out of town tags with a driver and a person, I believe, near the driver's side door, which he didn't say it, but obviously everyone in the criminal system knows that could potentially be a drug transaction.
Correct.
And then more particularly, Mr. Francois, the witness testifies that I believe he's claiming that Mr. Francois was the person that was somewhat further away from the vehicle, but then I think the testimony and the affidavits say that he alleges Mr. Francois attempted to hide and then walk away down this path that we've talked about.
Correct.
And why would the totality of all of that up to the time of your point in the timeline we say is a detention, why would that not form reasonable suspicion?
I specifically asked the deputy on his panel cross-examination, leading up to his apprehension of, he had nothing. He did not have a reasonable suspicion that a crime had occurred, about to occur, or did occur. I asked him specifically. So his intent to follow Mr. Francois on the path. At that point, there was nothing. There was no criminal activity, no hunch, nothing. And that's the issue in court. Use the word could. Mere hunches, mere suspicions are not enough to establish probable cause.
Okay, thank you. You got anything else?
That's all.
Thank you.
And I addressed that on cross-examination.
All right, Ms. Wilson?
Thank you.
Okay. Back to Owens again.
I wasn't sure if you kept that or not, so I'm pretty sure. That's contrary to testimony, the officer smelled the odor of marijuana on the defendant. When he approached, he came up beside the defendant, pulled out his windows very confidently. He said he immediately started to look for one, and he testified that at that point, he believed he had probable cause, he could have had probable cause to search him. However, it was that this defendant is known to him, and that he is known to have weapons. He decided that it would be better to wait until he was up ahead, but it's a well-lit area, and stop out at that point. And as the court will possibly remember from the video, as he comes up on at the end of where that sidewalk is, that they're walking on, once you see that, if you look, there's a pretty good area. There's a medium in the middle of it, and he actually went all the way up and into the area of the medium. That's where he stopped. So therefore, Your Honor, he could have went backwards, he could have went forward, and he could have, I know the officer said he walked right out of his car with that, but if you will look on that video, you'll see that he actually would have had plenty of that defense in regards to Hill, Horn, and Lane, quite frankly, just don't apply to pass this case. Those cases all deal with a police citizen encounter involving a consent search. Does not involve a consent search or a consent encounter. This involves the officer selling their marijuana, and at that point, he's able to have the right to detain him and search him at that point. Just delay it go up. It doesn't matter whether he answers the question or not. The officer did answer on the stand, and he was asked why he wasn't answering. But the first time he went to answer, he started ranting. He had told him the first part, said was the fact that why he was in the community. And he said when he started ranting, and so he just let him go. He said it was so later that he asked him the question. Whether or not he's telling me why he's being detained, as long as the officer has the right to, at that point searching, he could do it. And of course, getting back to the fact that last time we did, the state has to approve that, not solving this case, not around other people, and the state agreed. Case law is that there have been several people there and generally smell the odor of marijuana. You can't just search all of them. It has to be detected from that one, certain individual or all of them. So that is just the line of the state. The state case that I'm depending on is Owens v. State, and just for the record, that effect before the 16th filed March 1st, 2021, and the case number is 20-537. And one of the things that, and I'll read this is a vehicle case, but there's important observations and comments made by the court. On page 2, beginning of the first full paragraph, says, we are aware of the decision of the County Judicial Circuit Court of Florida that held that the smell of marijuana in connection with the traffic stop cannot constitute a sole basis supporting probable cause of search. And they go down and they said, we hold that an officer.
Well, they first said, with all due respect to the capable and experienced circuit judge.
I did, Robert.
Oh, I'm sorry.
It's supposed to go, 20 months ago. But yes, that is true. They did say capable and experienced circuit judge.
They made a mistake.
Yeah.
We're going to take it work out.
Said we hold that officers smelling odor of marijuana has probable cause to believe that the odor indicates the legal use of marijuana. Now, in that part of the statement, they're not even dealing with it. They're still going back to what has always been the holding for many years, is that if officers smelling the odor of marijuana has probable cause to believe the odor indicates the legal use of marijuana.
So you don't agree with Mr. Vergaramo's interpretation of Owens and the significant case law before it, that it's limited to searches of vehicles based on the odor of marijuana?
Right, I agree that this case involves a vehicle. There's several things that they discussed involving concerns in a vehicle. However, like I said, they do make other comments, like on page 4, it says accordingly, we conclude that the recent legalization of hemp and under certain circumstances, marijuana does not serve as a sea change to an existing precedent, and we hope that regardless of whether the smell of marijuana is indistinguishable from something else, the smell of marijuana in this town, this case was the vehicle, but I think what they do, it doesn't serve to sea change everything that's in existing law. One of the cases that they passed up on is Brady State, section 1243. And in that case, what they held, so this is one of those case precedents from section 1246. An officer who is trained, recognized, and is familiar with the odor of marijuana as probable cause based on the smell alone to search a person or a vehicle for contraband. So in this case, I'm not arguing that this was a search, it's obviously it's not a search case. But once he smelled the odor of marijuana, and he said that once the defendant walked up towards the car, he smelled it even more. At that point, regardless of, he asked if there was medical marijuana in the car. He did have the license, and he went in there and he called it in. And he was actually, at this point, he's already got probable cause of search. He's now, for this to investigate further, he is now at this point calling it in and asking if there's a medical marijuana car. But, which was an extra precaution before he actually searched it. So it's not like, he's holding on to the paper forever. We got a 13-minute thing, and that's all the way to the beginning, up to the stop. And at the point that we get there, we were, 10 minutes in? So we're not talking a huge amount of time in which Johnson had possession of this license, because at this point, he is detained. He would agree he is detained, and that's because there's public cause based on over there.
So at what point in the timeline does the state believe there was a detention?
I think it takes quite a bit of time on the first part, but I think that he could have detained you right from the point that he's driving up beside him. He's got a window down, and he said he smelled odor of marijuana then, but he made the choice that, he could have done it, and he did testify. There was no way that he would have recklessly jumped out.
I thought the witness testified that when he first pulled up to him, he would not have been able to detain him based on a very faint odor.
No, he said that, he said, first of all, when I questioned him, he said that at that point, he smelled the faint odor of marijuana, but at that point he could have, and wouldn't have stopped in that reason why he felt it was safer to actually go up into the clinic area. Then, he was questioned with regard to his deposition, and he made it very clear that he said that he could not recklessly, if the defendant had decided to turn around and walk the other way, he could have recklessly tried to turn around at that point, so it stopped him to detain based on the faint odor of marijuana. That's a lot different than saying, I don't have probable cause of it. He just felt that was more reckless, and that's what he actually stated and very on the stand. But at that point, we have an officer who has been trained and experienced in odor and detection of marijuana. He smelled it. At that point, he had the right to detain. So even if he says, I wouldn't have, made that reckless thing to go back because it would have been reckless. It doesn't matter. He didn't have the right at that point to detain him, and I'd argue that he did. And then he waited, he got up in front, and then he smelled the odor of marijuana more. And at that point, he can detain him, and he can search him. So regardless, it doesn't matter how whether he told his right place or not, because quite sure this wasn't free going at.
Anything else?
There you go.
Rebuttal?
Very brief, Judge. We're assuming that it's an odor of marijuana. The reason why we have to assume that is also testimony from training. That's a key fact in this case. July 2019, hemp became legal. And hemp, testimony from the officer, he's aware that it's distinguishable in odor as well as appearance. He has no training. His assisting deputy showed up and said, is there hemp? Never addressed that in his investigation, even though at that point I believe Mr. Frank Wild was detained with that. The officer still never addressed it. Testimony was he did after his place in handcuffs. That's an important factor. And the other issue is the green case that the state submitted from 2002. Hemp was not legal at that point. July 2019 is when hemp came into place. And I agree my cases aren't factually on point, but it's the holding, it's the rule of law. The totality of the circumstances where the legal person believes is free to leave or being detained. And the court inquired on the timing factor. This is the big time factor, was a reasonable person. And I think Mr. Francois' questions to the officer show that he felt as a reasonable person he was not free to leave because there was a vehicle chasing him on a pedestrian walkway with 8-foot chain link fences. Subsequently, the officer gets out of the car and asks for his identification. The entire time Mr. Francois was compliant. So hemp has been a change in the factors, and it's a new evolving issue, but it's something that was not addressed in this investigation that should have been because of the distinguishing factors between the two.
Well, why does that matter with this language in Owens on the last page? That the recent legalization of hemp and under certain circumstances, marijuana does not serve as a sea change, undoing existing precedent. And we hold that regardless of whether the smell of marijuana is indistinguishable from that of hemp, the smell of marijuana in this particular case emanating from a vehicle continues to provide probable cause for search of the vehicle. Because whether it's a search of a vehicle or a person, if they're saying it's not a sea change, why would it matter if hemp is involved in this investigation or not?
And that, I was going to address that.
Okay.
It addresses the vehicle twice, any vehicle. This is a different fact pattern. Driving an instrumentality that could potentially cause danger, either being under the influence or having a narcotic effect. The statute specifically states you're not to use hemp or marijuana while operating a dangerous instrumentality. So there's a distinguishing factor. He's walking down the sidewalk. At that point, while he's walking, he has no reasonable suspicion or probable cause to stop him at that point. So he's doing nothing wrong other than being whistler's code, which is not a crime. So there's a big distinguishing factor between operating a vehicle, which could potentially DUI or harm an individual, or be in violation of the statute, the medical marijuana statute. So there is a distinguishing factor. Now, the other thing is that hemp is legal. Marijuana is legal if you have a car. You have to be able to walk around on a pedestrian path. And if you're going to utilize your medical marijuana and or hemp, there's going to be an odor. There's going to be an odor from someone that's utilizing legal hemp or legal marijuana. And that's why the officer should be trained on the at least inquire about that, rule that out as before they go into, we're not even addressing this case. So if an individual, I mean, if they're utilizing either their prescription or this legal hemp, they're going to smell marijuana, but not driving a vehicle. There's going to be an odor. So I think that's the distinguishing factor. It's really nothing wrong walking down the street.
All right, I believe that concludes the hearing.
Yes, sir. The only thing they can come back with is right to find out more. They say we hold that not to smell the odor of marijuana as possible, that the odor of use of marijuana. And that, that doesn't state only the county.
All right, I do obviously want to consider the case law, think about what the arguments and the evidence have been presented. What are we currently scheduled for in this case?
I just that fall through the case management pre-trial is,
Okay. When is that next date?
May 3rd, I think.
Okay. That's for case management conference? Okay.
Or not for a trial cycle?
Yeah, we tried starting May 2nd.
Okay, so it must be a pre-trial conference?
All
All right, and that's for a May trial cycle?
Yes, May trial.
And what's the trial week?
5/14. I think it was that's right there.
I don't know. I'm the one with this.
And you ever just look like they got changed to a CDC from a pre-trial conference.
Perhaps if this motion was
And
pending.
that's got the whole different case party.
Well, at this point, is time of the essence for either side?
Okay.
My preference would be just to set it for a final case management conference in May.
Okay.
By then, I will have a ruling that I can announce, and I actually would probably prefer to set that now here in court. I'll probably do an oral ruling. That's the quickest way to do so. But
Madam Clerk, it's 5:18 a.m.
Oh my gosh, you got me. I'm sorry.
I have May 4th for a free trial.
Yeah, and I have May 18th.
yeah, so I'm going to cancel.
Which is a counter call that we set, I thought. It's really good. So yeah, we just did the AFC.
Right, I'll cancel all pre-trial trial dates at this point. The case management date for May appears to be May 6th at 1:30. May 6th at 1:30, so that'll be the only date. And Mr. Francois, his appearance can be waived. He's welcome to come. Well, actually,
I'm looking at your.
yeah, but I don't think I'll do it that day.
Okay.
Let me go see if I can set a date in advance of that.
Because Judge, we can only set it from that May date. We could set a disposition or a ruling from the date from the case management. That way we're not putting pressure on you for the timeline.
That may be the best thing to do. If I can have a ruling before that date, I'll distribute it to you, but if not, we'll set it from there.
Right.
So to keep it simple, May 6th at 1:30. Thank you for your polite attention and patience, Mr. Francois.
Thank you, Your Honor.
Thank you, Judge.
All right. Good night, everyone.